Let's talk about termination of employee. Employers in the Philippines can only terminate their relationship with an employee if a just or authorized cause as defined under the law. Terminating an employee in our country is taken very seriously and can be a complex process, especially since, when in doubt, the Labor Code of the Philippines is construed in favor of employees. There are two types of employment termination in our country. First is termination by employer and voluntary resignation. Employers can dismiss an employee based on just and authorized causes. Just causes are based on acts attributable to an employee's own wrongful actions or negligence, while authorized causes refers to lawful grounds for termination which do not arise from the fault or negligence of the employee. Voluntary resignation is defined as a voluntary act committed by employees who knowingly dissociate themselves from their employment for personal reasons. It does not cover instances where employees are forced to resign with the use of threats, intimidation, coercion, manipulation, or where dismissal is imposed as a penalty for offense. Forced or coerced resignation is illegal and considered as constructive dismissal. The question is, the employer has the right to terminate the employee. The answer is yes. Before the employer terminate the employee, it should undergo due process. First, the employer should provide intent to dismiss, and inside that letter, it must specify the reasons why he or she will be terminated. Second, hearing or conference. The employee has the right to respond on what is being accused towards him or her. Lastly, notice of dismissal. It should notify the employee that upon due consideration, he or she will be terminated. Termination by employer according to Article 282 of Labor Code. An employer can terminate an employee for just causes which could be any of the following. Hope it helps.